All right, thank you. For attending, and I'm going to turn it over to Laura and Deborah.
Great, thank you so much, Patrick. This is Laura Faer from Public Counsel Law Center, and I'm the Education Rights Director.
And this is Deborah Escobedo from the Youth Law Center.
And we can go to the next slide. We're really excited you all have joined. We have a couple goals for today's training. First, we want to tell you, give you some information about school discipline and its impacts in California and on students in California. And then we want to give you some updates on some of the legislative activity that occurred during this last legislative session, some very exciting victories and also some challenges. And our hope with this webinar is not only to tell you about the new laws and their impact, but also to really encourage you to use these laws in your community to make certain that your school districts actually put them into practice and put them into their board policies, and to give some thoughts on how you can also use the actual language in the laws to bring about greater systemic reform. We also want to give an opportunity on the webinar today for you to give us some input about other things you're seeing in the communities that you're working in around the state and in your legal advocacy representation about other systemic problems in the discipline area and facing students. And so when we get to that point in the webinar, we hope that you will send in your ideas to Patrick or using the chat screen as well. And you can also email either Deborah or me with any of the ideas you have and any thoughts you have. And we'd love to engage any of you further this year around helping with some of the statewide systemic reform. So if you're interested in that, we hope that you'll also email us and express an interest in getting involved in the policy change efforts. So the first thing we wanted to talk about, obviously, many of you probably know, that education in California is a fundamental right. This is really important because it is a fundamental right, obviously, our students in California are entitled to appropriate due process protections before they are suspended or expelled. And so our education code, and in particular the discipline code, really is about ensuring that we have fair procedures before such a right is withdrawn. And it's important to know this is one case. Obviously, there's also others, Gospi, Lopez, and others that really establish this right. And the education code itself obviously spells out the specific rights and procedural protections that exist for our students. Next slide.
Now we're going to talk about the need for discipline reform in California. And you have to understand, this has maybe been like it seems like forever, but it's been like a year-and-a-half process where various organizations, both advocacy organizations, both legal organizations, community-based organizations, got together, formed a group, and actually started looking at the discipline code and the need for discipline reform in California. Next slide, please. And as we prepare to do sort of our legislative advocacy, the first thing we wanted to do was look at just the raw data on suspensions and expulsions in California. And I don't know how many of you have been to DataQuest, but this particular data came from DataQuest, which is on the California Department of Education's website. If you've never been to DataQuest, you need to go there. You need to find out what's there. But it's there that you can get the sheer numbers of suspensions and expulsions in California. The good news is that the numbers are at least going down from year to year. The bad news is just the sheer number of students being suspended and expelled. And actually, when we brought this data to legislators, they were actually shocked by the numbers. You should know that this represents incidents of suspension and expulsion and not actual students suspended. And there are, in fact, more diplomas given out, less diplomas given out in California. More suspension notices given out than diplomas in California. So that's not a good thing. It's not something that we can be proud of. Next slide, please. In addition to just the sheer numbers of kids being excluded from school, we also wanted to look at which groups of kids were being suspended and expelled. And unfortunately, the state of California, at least for the last several years, does not disaggregate suspension and expulsion data. Hopefully they're going to be doing that soon. So we pretty much had to rely on the Office for Civil Rights data, and that came from 2009, 2010. And I have some of the information here on the slide for you. The most telling statistic to me is a black student in California is 3 times more likely to be suspended than a white student. Also, the percentages concerning kids who are disabled, and in particular, black male students who are disabled, they are even more likely to be suspended in California. So, you know, you can't, unfortunately, get, like I said, you can't get disaggregated data on DataQuest, but there's a really good report that I recommend all of you read. It's called Suspended Education in California, and one of the materials that we have available on the LAC website is School to Nowhere web resources, and you can find a link to that report on those web resources. And that report actually analyzes the OCR data. This is where we got this information, and they actually have the actual data for around 500 school districts in California that you can just look at without doing your own analysis. Next, please. In addition to the numbers and the disproportionate impact, we also wanted to look at on what basis kids were being suspended and expelled. And this data I got directly by asking for it from the California Department of Education. They actually gave me their Excel sheet. You can get the grounds, but you need to go to the site level report, and you have to kind of go to every single site, since that can be kind of difficult for larger school districts. But I actually have done that for some school districts. The most shocking thing to me is the percentage of kids who are being suspended for willful defiance. And this is, school districts are asked for this information, and they're asked to give the most severe grounds cited for a particular suspension. And as we all know, oftentimes kids are suspended for several grounds. So whenever they put down willful defiance as the most severe, that means it was the most severe grounds. Okay, and then we are also surprised to find that it's the third most severe grounds for expulsions in the state of California. Now, for those of you, there are some non-attorneys on the call, so for those of you who are not familiar with 48900K, I'm going to read it to you. It says, disrupted school activities otherwise willfully defy the valid authority of supervisors, teachers, administrators, school officials, or other students, school personnel engaged in the performance of their duties. Nowhere in the Ed Code are any of the terms of that provision defined. And actually, research confirms that on the national level, youth of color are disproportionately disciplined for those offenses that require a judgment call by school staff, such as willful defiance. Now, the state data on willful defiance is 42%, but I'm going to give you some data that I actually looked up for several school districts, and you're going to be shocked by some of the data. For Manteca Unified, 58% of all suspensions were based on willful defiance, and I'm talking about the most severe grounds. San Bernardino City Unified, 61%. Santa Rosa City High Schools, 61%. LA County Juvenile Court Schools, 70%. Clovis Unified, 70%. Kern Union High School District, 57%. In Manteca, I looked at one high school, and you kind of have to make a jump and kind of look at enrollment and other factors, but one high school had the highest rate of suspension of all the high schools in the district, the highest willful defiance percentage at 83%, and the highest percentage of black student enrollment of all the other high schools in the state. I was shocked by these percentages. I'm also shocked when I go in to look at the data, and I find very high numbers of kids being suspended at the elementary level, and you're going to find that there are very high percentages of elementary school kids being suspended for willful defiance.
And Deborah, just one quick thing. Carrie Lou had a great question, and this data, the expulsion data, just to clarify for folks, is only those that are actually expelled.
That's my understanding, yes. Okay, that's next.
So it doesn't account for, you know, if there's a suspended expulsion, there may have been someone referred for expulsion. So it captures a smaller number.
I think that's right. Next slide, please.
So the next piece of this is we want to talk about the discipline bills that actually were signed into law. So next slide. So we started off with a larger number of bills. We started off with 8 bills, and what you will see is that at the end, we had 5 that actually were signed into law on a number of different topics. And as Deborah was saying, that the ideas for these bills came from several different places, but there was a statewide coalition of organizations of all types that got together, and sort of over time, obviously, we've all been working on these things in the ground, and we start to see very systemic issues that are bubbling up in a number of different areas. AB 1909 also came really out of the really thoughtful discussions that the California Foster Youth Education Task Force had around the needs of foster youth. And Carrie Liu and others were integrally and part of her organization co-sponsored that legislation with Public Counsel. So let me give you just a quick overview, and then we'll get sort of into the nitty-gritty. But AB 1729 is really about strengthening in our code the other means of correction section. As many of you probably know, the code requires for most of the suspendable offenses that you really must utilize and show, in fact, that it's failed another means of correction before you use a suspension. So I always like to think of suspension as really the last resort. AB 2537 is about zero tolerance. And really, when I'm talking about zero tolerance today, we know that there are practices in schools where administrators and others are acting in a way that's zero tolerance. But when I'm talking about it today, I mean the actual code sections in the California Code that say you shall expel and suspend for this offense, or you shall unless suspend. So really the true limiting of the discretion requiring a removal. ABA 1909 is really about foster youth, another group that is very disproportionately targeted for suspensions and expulsions in California, and we'll talk about notice and engagement of key people in the process and why that's so important. SB 1088 is, I call, the stopping the off-the-books expulsion for our juvenile justice youth, because really what we see that happens is many of our young people who've had even one contact with the juvenile justice system are oftentimes told they cannot come back. And there's no due process provided. They're just sent away. We've had a number of folks in our office, young people who have come to us 2-3 months more out of school. And the statistics at the state levels confirm that the ability for our young people to get back into school, and particularly in their comprehensive school, is really compromised once they've had contact with the juvenile justice system. And AB 2616 is about really aligning our truancy laws with best practices and taking some steps in a forward direction. While you cannot, under California law, suspend a child for being absent, we've seen some really harsh practices that are part of the school-to-prison pipeline and sort of this trajectory that we put children on for removals. And so our practices, unfortunately, in this area have been resulting in more children actually not coming to school. At least in LA, we have a lot of data on that. And it's also really impacted the ability of young people and sometimes their parents to really engage in a dialogue about what's keeping them at school and to get to the root causes. Next slide. So there's a few things about AB 1729 that I want to make certain that we highlight for you all. First, really key thing is that AB 1729 has some really wonderful, strong legislative intent language. And if you go to our fact sheets that have been emailed out to everyone, you will find the specific language. We have some of it in this webinar as well. But it really, for the first time in code, declares the intent of the legislature that disproportionate impact on our vulnerable groups is not acceptable in a very strong way, and also talks about how the policy of the state is really to focus on alternatives and not on school removals. So this language is really, is a really good tool that we hope that everybody uses in their communities to really encourage and strengthen the alternatives that exist under the other means of correction provisions. Also, prior law, it required other means of correction to be used and failed prior to an out-of-school, to many of the out-of-school suspensions, and now the language includes in-school suspension. The new law also discusses about that other means of correction may be documented, and such documentation can be accessed as a pupil record. And the important thing about this, even though it has may, it is not a shall. We started off with a shall, but through the legislative process it became a may, is that in my mind, what's really important about this is that we really do want to start seeing more of the alternatives that are being used documented, and that when our law says you must show that these have been used and failed, there should be a way for you as an advocate or a community organizer or a parent to go and ask the school to show you what they've done and to have proof of it. And this, by doing this, we also ensure consistency and fairness, so that a child that's in South LA or a child in West LA is getting the same types of alternatives put in place before they're removed before school, and the same types of interventions are being applied regularly. Another important thing about this is that it provides a comprehensive list for us of what is recognized in other means of correction. And why this is important is because we've been hearing a lot around the state from many people, what does other means of correction even mean? What would be included? What should I do instead of suspend? Suspend is the easy thing. It's punitive, it's quick, and so we have to change the mindset and get people to realize that what young people need in order to help change behavior and make schools safer is something else that helps them to grow and strengthen, and that also addresses, school climate. And so it now includes research, some of the best research-based, evidence-based approaches, including school-wide positive behavior interventions and supports, and restorative justice as other means of correction. And again, this is a tool we hope that you all will use to begin the discussions with school districts around the state about actually making this a reality in all of our schools, a true plan of other means of correction that's documented and fair and consistent. And then last, and very importantly, it narrows the exception for when students may be suspended on a first offense. And so the two pieces of this are threatening to disrupt the instructional process and threatening causing a danger to property. And as Deborah was talking about before, willful defiance, right, the 48900K talks about disruption of the instructional process. And we think it's really important here that, again, it's reaffirmed in this section that a removal should not occur until, again, other means of correction have been used and have failed. Next slide. So this is, I'm not going to read this to you, but here are a few of the sentences of the legislature's intent that are in the code. And you can look again in our fact sheets to find all of the language. But as you'll see, it talks about research about the importance of non-punitive classroom discipline. It talks about effective interventions, avoiding exclusion, the disproportionate impact on our vulnerable populations, and that we want to, undermine the fact that for our public policy reasons, we know that overuse of these school suspension and expulsion does not result in safer school environments. Next slide. And so, again, this is also the list of the other means of correction that are included but not limited to the following. I'm not going to read them out, but you can see them here and also in the code section. AB 2537, which is the next bill, really, again, is about, there we go, clarifying zero tolerance. It does a few really important things. It provides some additional discretion for administrators in a number of circumstances under the code for them to really to not make a recommendation for expulsion. And what we had heard from folks around the state was really that, including administrators, where they would really felt like their hands were tied in certain circumstances. Even though the existing code said that if it was inappropriate, you did not need to refer for expulsion, we were hearing that there was a lot of confusion about what that language meant, and that administrators didn't feel totally comfortable using it. So this really, again, focuses our attention back on, if there's another means of correction that would address the conduct, let's not refer the child for expulsion. Let's take another way to help them. Or if the factual circumstances don't warrant it. So if an administrator knows a young person, they know that this was a mistake, they understand the circumstances about how this happened, they have the discretion to not refer for expulsion. And we hope this, again, is also a tool that can be used with administrators to come up with what are the other means of correction, what else can we do instead to really avoid that very harmful expulsion process in the amount of time that young people are out of school. It also encourages in the law to make the decision sooner to avoid the loss of instructional time. We've seen young people who are out, many, many days beyond the 30 days because the hearing gets postponed, and that they are also, 30 days is not a short amount of time to be out of school before your regular school before the expulsion hearing. Many of the young people we've worked with have not had great access to other schools during that period. It also clarifies that possession of an imitation firearm, like a Nerf gun, a water gun, does not merit a mandatory expulsion. So this is important because we were also seeing that the numbers on young people who were being actually referred for mandatory expulsion for imitation firearm was pretty high. And so this makes it very clear that that's not mandatory. It also clarifies that possession of overcrowded medications or prescription is also not mandatory and not one for which expulsion should be automatic. Again, these are discretionary things we want to try to keep young people out of the expulsion process. And finally, it eliminates the fine for school administrators for willful failure to notify law enforcement for certain offenses. And again, this is about, really, is it necessary to fine a school administrator? And in our experience, we've seen really that children are very regularly referred to law enforcement, and to have this type of fine in addition, particularly in this budgetary time, seems very unnecessary. Next slide. So AB 1909, again, this is a bill that's really focused on foster youth. And what we saw actually in Elk Grove and was that which they were putting in place a really great system to ensure that social workers and the dependency attorneys who represent our foster youth actually were given notification about both suspensions and expulsions that were happening and any kind of school removal. And what was happening was that those folks were coming to the table, participating in the process, bringing in resources, and they were lowering suspension rates and creating more of a collaborative process between the districts and the court system and making certain that foster youth were getting what they needed. And so the primary thing that this bill does is, to a little bit of a lesser extent, because it applies only to certain types of school removals, not to all suspensions, but really to our discretionary school removals, both our extended suspensions themselves, our actual expulsions, and our manifestation determination hearings in the special education context. Next slide. And SB 1088, again, what this does is it clarifies the law, makes it much stronger. It essentially says that if you have had a contact, including an arrest, adjudication by a court, probation, supervision, detention for any length of time, that you cannot be denied enrollment or readmission on the basis of that contact with the juvenile justice system. And again, this was something we've been hearing from all around the state. We've heard it from probation officers. We've heard it from attorneys. We've heard it from young people. We've seen it in our own practice. This was happening regularly despite the fact that such a denial would really be a violation of the Constitution, state constitution, and there was really no justification for it. But this is a tool now we hope that people will be able to use regularly with young people, and we really want to see and make certain that school district policies and practices are in line with this code so our young people are not being denied re-enrollment. Next slide. And AB 2616, as I said, it does a few things. One is that it gives administrators some additional discretion to determine when a student has a valid excuse for being truant or tardy. And the importance of that is that we were seeing in LA and in other places in the state that young people, particularly low-income students and students of color, were getting the majority of infractions for being truant. They were the ones who were being regularly identified as being truant, and oftentimes there were mitigating circumstances. So if you are a young person and you're on your way to school and you're late in the car with your mom because your mom drives you to school every day, you're not going to get a truant because you got your mom with you, and you're going to avoid some of these issues. But if you take the bus and that bus breaks down or the bus doesn't pick you up, you're out of luck. And so we want to make sure that the discretion of administrators to understand the facts and circumstances is there, so it's not an automatic push into a system that really can result in law enforcement contact and can result in much harsher penalties for both the child and the family when that may not be necessary. Also, the best practices in the research show us very clearly that involving a young person in law enforcement who is having problems with attending school and being late to school actually has the opposite effect. You know, it does not actually get our kids back to school. It pushes them further away from school. And actually, if they are engaged in the juvenile justice system in any way or appear at court, they're 4 times more likely to drop out. So this really encourages, on the first truancy, the school to actually have a meeting with the student and parent to discuss the causes and create a joint plan to improve attendance. And it says encourage here because it's not a shall, but it replaces what was the first suggestion by the legislature, was to send the child to the police. So we're hoping that we are creating more mechanisms and that in your communities you can actually take this encouragement and now go to the school districts and say, we want to put in place something where we actually have a dialogue. We want to put in place something where there's attendance plans, where we have a better system for helping our young people. It also now provides discretion as to whether to involve the child in the juvenile justice system, takes away the mandate of an automatic jurisdiction over the court. And it caps the fine. It caps the fine that if you're under the court's jurisdiction, caps it to 50 without penalties and fees. Next slide.
And Laura, someone's asked a question about, I think you've referenced fact sheets.
Yeah, so I'm sorry, I'm not seeing those second questions. We have sent out some documents for you. Oh, do we not send out the fact sheets, Deborah?
No.
Okay, I will send the fact sheets out. We're going to get them out later today. There'll be a fact sheet on each of these bills that we hope you can use all throughout the state, and it will also have an attachment that includes the actual bill language. You should have already received by email a bill chart that also includes all the very, very specific language we're talking here, and it has it all highlighted and in red, and you can print it out and put it on your wall, and you can look at it more closely yourself to see what the new laws say. Yeah,
in addition to the bill chart, we have the School to Nowhere web resources that I've already referenced, And we also have a How to Research California School Suspension and Expulsion Data memo, and that's all should have been distributed and also is available on the LAC website. And if you have any problems, just email us and we'll send it to you. So next is missed opportunities, basically what got vetoed and what got killed in appropriations. Two of the in my view, the most significant bills were vetoed by the governor. This is AB 2242 and SB 1235. I'm sorry, next screen, please. Okay, and there they are. Anyway, in my view, both of these bills address the issue of disproportionality. AB 2242 would have eliminated the current language of willful defiance as grounds for expulsion. The original bill would have eliminated as grounds for suspensions also. And AB 1235 would have encouraged, and I stress encouraged, various activities by school districts depending on whether or not 25% or more students suspended or subgroups of students were suspended, and would have made them look at those figures, God forbid, and also maybe have them, encourage them to do alternatives and to look at things like PBIS, which Laura's going to talk about later, and restorative justice, or she might have already mentioned it under other means of correction. And that, by the way, that original bill with all these activities were mandated. Also, the California Department of Education also would have provided technical assistance and trainings to these school districts. All of that was originally mandated, all became just a big encourage bill, but nevertheless, both these bills were vetoed. Next, please. In the veto message, the governor referred to local control, which is subsidiarity. And by the way, so you should all know that is his official portrait in the state capitol, if some of you have not seen that. Also, with respect to the issue of willful defiance, even though he refers to local control in his veto message, there's this great report by EdSource where they did a survey of administrators on various issues in the context of discipline. And with respect to willful defiance, many administrators admitted in the survey that they were struggling with this provision, and they were asking for a clear definition. And they also agreed with us and said in the survey that it was subject to overuse and misinterpretation. So we were on the right track in terms of this bill. I highly recommend that you look at the EdSource report. It's called Understanding School Discipline in California, Perceptions and Practices and Practice. And again, the link to that is on your School to Nowhere web resources. Okay, next, please. You know, and I've been hearing local control for many, many years. It all depends. They always use it when it's to their, in my view, to their convenience. They don't want to say local control with respect to the rights of LEP kids. They want to impose Prop 227 on everybody. But nevertheless, you know, we've already shown that 48900K is so subjective that students of color are disproportionately suspended and expelled in California schools. This is a civil rights issue. There is a good law saying that it is clear that the state has a clear obligation to address these sorts of issues, and they can't just refer to local control when it comes to issues of civil rights. Next, please. Okay, now, what died in appropriations? I have to say, it was very, very, the hardest committees to get through actually were appropriations on many of these bills, and it's almost as if they looked for reasons.
Just for clarification for folks, the Appropriations Committee, as many of you probably know, is the committee where they put a price tag on your bill and decide whether it comes out. And obviously in this cycle, the budget, you know, looming large, there is only, you have to have a very, very, very small amount of cost to get out, or else they put you on what's called suspense, and then there's a process where you have to amend your bill. So it is the, things die. This is where things often go to die.
Yes, and in fact, you're going to see when you look at the bill chart, you're going to see kind of, I would think, some kind of strange language in some of these bills where it refers to discretionary acts, and that was the only way we could get some of these bills out. Okay, so we had to add a lot of different language, and Laura was very good at doing that. So these are two of the bills that were vetoed. I'm going to focus on AB 2145, and that was a data bill. And basically what it would have required is for the California Department of Education to collect suspension and expulsion data through CalPADS and to disaggregate it by relevant subgroups and to post it on DataQuest. Now, fortunately, we believe that the California Department of Education, and they have said to us that they are going to disaggregate the data, but you know, they're doing this because they have some good people there right now and they think it's the right thing to do, but we didn't want to rely on just whoever was in charge of CalPADS in the future to do this. because we've learned that they do change CalPads from year to year. For instance, I just found out that they may not post truancy data there anymore. And if you look back at the discipline data maybe like 5 years ago, they had a lot more information about data. And in fact, as Carrie mentioned, I think they even had suspended expulsion data on DataQuest. They no longer have that. So unfortunately, appropriations, both these bills died there. And I have to say, as Laura said, it's very difficult to get some of these bills through. One consultant actually said on one of our bills that it would cost too much money because there would be more kids would be in school because they would not be suspended, and therefore they'd have to pay more average daily attendance funds to school districts. They actually said that. Next, please. Okay, now there was really good, even if some of the bills were vetoed and some of the bills maybe weren't as strong as we would have liked them to be, some really good things came out of this entire effort that are not necessarily reflected in our bill. As I just said, the Department of Education has made a commitment to produce disaggregated discipline data. That should be up in maybe a couple of months. I'm going to find out more information on Monday. And it's my understanding, at least right now, that it will be disaggregated. It will also be disaggregated by grounds. We're hoping for that. Willful defiance, we really put that on the table. I mean, I had very conservative legislators, when we talked about willful defiance, they would look at us and say, well, what's that? And they go, willful defiance, how can you tell if a kid is willfully defiant? Some of them would say, you know what, too many kids are being suspended for things that we did when we were in school. We would get in fights and we would not be suspended. So many legislators, they kind of got the issue, I think. Also, we wrote several letters to, we wrote a letter to the Department, to Superintendent Torlakson, to the State Board, and to the Attorney General on issues of suspension and expulsion. We got varied responses. I have to say, Superintendent Torlakson was very responsive. He met with us. He assigned one of his staff people to continue having meetings with us, and we're having those meetings. They've agreed to do regional trainings for school districts on alternatives to suspension and expulsion. And much to my amazement, they actually agreed to consider including disproportionate discipline in one of their monitoring instruments, and that's the educational equity reviews, and we're talking to them about that. I've never had anybody from the Department of Ed agree to include something in monitoring, because normally in past administrations, they were not really friends of monitoring whatsoever. The State Board of Education, in my view, has been maybe less responsive, but the board president did meet with us, and we did, at his suggestion, we actually went to a board meeting and testified about the discipline data contained in the SARC, in the School Accountability Report Card. Unfortunately, it's my understanding, unless Laura has an update, we have not gotten any response yet from the Attorney General. Next, please.
So this is a key part for all of you, we hope, is we really want to make certain you all know that half the battle is you get something on paper, but then really the question is it actually going to make a difference, right? And so we want to make sure the reforms actually get into our schools and in our classrooms, and that means that we need everybody on board. Someone has asked a question about whether there are advocacy projects that they can get involved in. We'll talk about that a little bit more. We'd love everybody on this call to get more involved. And you can go to fixschooldiscipline.org and actually sign up there, and you'll get alerts and information and more webinars. And if you are wanting to do more, you can, again, email Deborah and email me, and we'll link you into some other ways that you can get involved as well. Next slide. So these are things that we think don't require a huge, statewide effort. These are things that we hope that people will consider doing in their community, because really the most important thing now is that these actual state laws actually get into our school district policies, our manuals, and that there's actual education that's done, not just for our teachers and our administrators and everyone, so everybody's on the same page about what the law requires, but that there's also education to parents and community members, and everybody is engaged in this. And so, as you can see here, the law really already requires that school boards have rules that are not inconsistent with the law. Parents also have a right to be informed in advance about what's happening with these school rules. And in developing the rules, right, so taking the laws that we've just talking about and putting them in policy, they must have participation from a number of different groups, which is great, right? So it includes, obviously, parents and teachers and administrators. So these steps and these laws, give access. And so what we'd love for you to do, next slide, is, you can request a copy of your district's policies and rules, right? And you can usually find them, you all probably know, in a parent-student handbook. You can find them on the school district's website. And you can also, if you're, you can ask your school board members where they are. There are some districts that do a better job of posting all of their policies and rules on their web. Some don't do such a great job. You can also send out a Public Records Act request to request all the discipline policies that are on the books. We will have on fixschooldiscipline.org, in the end of this month, we will actually have some sample Public Record Act requests that folks can use and adapt, and includes requests in there for all policies. So you obviously want to check to see are the new laws in there, and then we hope that people around the state will be advocating for the districts to change the policies, and also really to educating school personnel. Because even if they change their local policies and there's not education at the principals meeting, at the teachers meetings, at the school site councils, that then it won't actually get into our classrooms and into our schools. Next slide. So, the ways, obviously, to advocate for change, there are many. Many, I'm sure many of you use, but obviously meeting with the principal, meeting with the superintendent, meeting with your school board members. You can request a board hearing, get this actual item agendized. You could actually go to the school board hearing and testify. Let them know these new laws are in place. You'd really like for them to put this a priority and make certain all the discipline policies are updated. Really, again, the education piece is really key. And you can also, if you're working with a school, you're working in a particular school, or you actually are a parent or a community member in a school, approach your school site council or your English language learners council and really look to see what their school site policies say, and have a discussion about this. Next slide. So I'm not going to go through again all the bills, but what I want to just give you a couple highlights for each of the bills that we've already discussed is what are the things that you can do, how else can you use these laws to make change, right? So for every one of them, I'm not going to repeat each time, but for everyone, if the school policies are not consistent with the new laws, they need to change them, and they should do them through a public process, right? And if there's no policy or rule on this, then it's a great opportunity to put something in place that's much clearer and can be used. So one of the things that we really suggest on the Other Means of Correction Bill, AB 1729, this is really a great opportunity to open up the dialogue with your district about what should be used consistently across your district, offered to all students to reduce suspensions and expulsions through other means of correction, right? And so what we've seen in a number of forward-thinking, progressive, leading districts in the state, they're already doing it. Right? So Vallejo City Unified School District, for example, their superintendent said, we see we have an issue. We're going to fix this problem. They are putting school-wide positive behavior support at every one of their schools and prioritizing this, right? And that is a very strong other means of correction with, interventions, and they're tracking their data, and they're doing all the things to try to really get at the root of the problem. You have an opportunity, we all have an opportunity now to ask the district, what is your plan for other means of correction? What do you do to make certain this law is followed? And look at these. If you don't know what they are, here are the ones that the legislature suggested. These are the ones that go into effect January 1st, 2013. We want to put something in place district-wide, right? It's also an opportunity to request documentation of alternatives, right? So to say, we're seeing there's disproportionality. When you start looking at that data in your district, you pull it up from the reports that Deborah talked about, and you say, hey, look, we've got an issue here in our district, and what we'd like to know is how are you going to be documenting to make certain that every school site is really giving children other alternatives, helping them to improve their behavior before we suspend them? How are you doing that? And so this is a way to really push and discuss at the local school site how we put in place better policies that actually work for all of our children. And I think someone asked, how reasonably can we expect them to update their policies? And I think, again, January 1st is when the law goes into effect. All these laws go into effect, and so it should happen around then. I've already gotten some calls from districts and others who are already thinking about it. But the truth of the matter is that there's a lot of priorities, and so if you are in a community and you start making this known, you can send out a letter, you can try to meet with your superintendent, you're going to help make it happen much faster, and then the community and advocates will be really a part of this process, which I think is really the best way for us to make changes and see really best practices happening and spreading across the state. Next slide. So also, obviously, these on this page are the other things that you need to change that are, again, very specific things that the policies on the local level need to change to make certain they're not inconsistent. I'm not going to read them again, but you can see, again, what the law requires, and the bill chart we sent does that as well. Next slide. So, sorry, AB25, I was reading a question at the same time. AB2537, again, the things that we recommend, in addition to obviously making certain the law conforms, is this is again an opportunity to talk with your school district about making a list of all the types of other means of correction that can address the conduct and avoid expulsion. So what I've found is that the more that we can give the guidance to our local school administrators, not as a prescriptive, but give them some of the options when they see that the school district central administration says, look, here are other means of correction that would work in lieu of expulsion. Then they feel much more confident that they can use their discretion and they can feel confident in relying on it. And it also allows parents and community members to have real tools that they can come to the table when they come to that expulsion, extended suspension meeting, before the expulsion referral is made, and have that discussion about whether it's going to go forward. They can have a really open dialogue about other means of correction. Obviously, I think a really one thing would be is to ensure that the law now encourages, right, that we make this decision sooner, because we want to try to avoid the number of days that our young people are out of school when they're being threatened with expulsion. And so this is another dialogue to talk about what would that look like? How do we put in place some policies at the local level that help move that process along at a faster pace to help potentially keep our young people in school and not sitting out of school? Next slide. And so AB 1909, as I said, this bill really is more limited than what they did in Elk Grove, but I encourage everybody to take a look at the EdSource article. It's on fixschooldiscipline.org. It came out in October of 2012, so you can look on our problems page, and you'll find all sorts of articles from all around the state around alternatives and what's happening in different places, and there's a great one about Elk Grove that talks about what they did. My recommendation for folks is, because each community is going to be different about how we provide notification to the attorneys and the social workers working with young people who are facing school removals. And I think the best way to really create a process that not only includes what the law requires, but may go above and beyond and get to a best practices model, which is Elk Grove, right, where you're also doing it for suspensions and you're tracking data and people are meeting, is to really convene a meeting with child welfare, your school district officials, the court, the foster youth attorneys, and try to figure out what's the best way to do this in your community. And see if the procedures can also include invitations to attend meetings when a child is suspended. It is an opportunity, again, to open up that dialogue, to have a good discussion in your community, and to really figure out what might be best practices in addition to what the law requires. Next slide. And for SB 1088, I think the really important thing is we want to make certain that we remove any provisions that conflict or contradict the law, because I think that's what we're going to see the most of. And also really educating all staff and school leaders. I hope that school districts actually use this as a tool. In LA, we saw that the central district did not want this to be happening, but there were certain school sites that were doing this to young people. And so this, again, is a tool for everybody. We also think it would be really important that when they're updating the policies, to really ask them to monitor school re-enrollment for their youth. So to really see, are schools actually allowing young people to come back, and to create some sort of monitoring procedures, even if it's some sort of sampling, to make certain this law is actually being applied. Next slide. And for AB 2616, again, we talked about really adding some provisions to the truancy policy to ensure that excused absences are really limited to what's defined in the education code, and also really requesting that a district develop some protocols to bring them some of the information on best practices. If you want to work on this piece, I have a lot of research and stuff that I can send you, and really encourage them to try to create some alternative ways to actually address attendance. There's actually some great articles, again, on fixschooldiscipline.org that talk about some really creative and innovative approaches that some of our school districts are using that really rely on working with community and parents and other sort of strategies that are positive in nature to help bring kids back to school and help families. And Baltimore in particular and Alhambra Unified actually in California are good examples of bringing in actually wraparound services and all sorts of other things to work with families. And so again, this is an opportunity to open up that dialogue in the process of trying to get these policies actually into district policy. Next slide. So what else can you do? Obviously, spread the word, educate. If you don't have time to do all these things I'm talking about, even just educating the parents and students that you are working with. Go ahead and feel free, frankly, to take this PowerPoint Use whichever pieces are useful to you. Take any of the tools we're giving to you, and please spread the word. This is all stuff that we hope are tools that everyone can use. Also, please report anything you're seeing. If you're seeing that students' rights are being violated, or a school district's really refusing to follow the law, please go to Fix School Discipline. We will shortly have an I Need Help button on that site. It's not there yet, but we hope by the beginning of December it will be up. And you can actually put in, you click on it, and you can actually write an email that will go to a public counsel advocate or an attorney, and we will either try to help ourselves or get it to someone who can help. I think also if you already know how to help, meaning you are someone who advocates for young people all the time, or you're also an attorney yourself, if you want to just report the information to us to let us know what you're seeing out there, that's also useful, so we can see what the systemic problems are and where there might be some more need for reforms. Next slide. So what else can we do to reform school discipline at the state level? Next slide. So I'm going to just tell you these are a couple of areas where we keep hearing from people around the state, from everybody, actually different types of folks, from school administrators to advocates to parents to community leaders. These are some of the things that keep coming up. And so I'm going to read you these very short, very quickly, hopefully. But I would really like, this is the part where I would hope if you have ideas yourself that you don't see on this list, just start sending little email chats that we can see. I'm seeing the ones that people are sending as questions right now about other things you're seeing in your community or things you think are really systemic in nature or that are problems. So the first one obviously is we're not done with willful defiance. We need to take a look again about how we limit its youth, whether it's defining this term more clearly or putting in place some really clear guidelines about what interventions need to be used before this is the quick trigger removal for kids. We're also hearing some really great ideas from people about teacher training and administrator training, right? So, how amazing would it be? Teachers, really deserve and need more support and more information about all these alternatives, and so do administrators, because so many of them that we talked to this year want to do this. They want to know how to do it. They want support. They want training. And so really looking at how we put in place more training on the front end when teachers are starting off in the practice and administrators are becoming administrators to, on alternative discipline, these actual research and evidence-based practices that not only keep our kids in school, but actually increase academic achievement, it's kind of amazing, increase attendance, lower suspensions, and they really create a better school climate. It's a very clear connection between all of these things. So they're really no-brainers, but they're not getting out as quickly as we would like, across the state, and everybody doesn't have the tools yet. So also looking at really some of these other things, structural racism, implicit bias, and how can we get this out in a very statewide manner. Also stronger investigation and enforcement at both the state and federal level. So really, if there are schools out there that are really refusing to recognize the problem, refusing to actually engage, refusing to do anything about it, how do we use some other tools to really get people on board? Charter school removals, right? So we've heard a lot about, hearing more all the time about the fact that unfortunately the practices really vary between charter schools in terms of whether they're providing due process or not, and the outcomes for our kids in terms of after they've been removed, getting back into another school doesn't always happen. Ensuring, obviously, that our expelled students have a meaningful opportunity to re-enroll in a prior school, and also curbing the overuse of extended suspension. So we've been hearing some things of late about a practice of administrators actually just referring for expulsion, even if it's really not an offense that you would want to expel for, just to start the process of being able to remove a child from the school itself, to sort of get rid of a child that's having problems. So those are a few of the things we've been seeing. Next slide, hearing about. Also involuntary transfers. Children being transferred to schools that are really failing students are, many of, as you might all know, as alternative schools are disproportionately enrolling a number of our students of color, and the data in terms of the outcomes is not so great. They have some of the highest dropout rates of all the schools in the state. So these are some of the things that people have been telling us potentially we'd like to look at. So are there other ideas? Do other people have ideas? I'm going to move on the slides, but I would really love it if other people have ideas. These ideas do not reflect what you're seeing, or you think this is off base. Please send emails in, little chat emails to us, or you can send them on the webinar right now about other things that you think should be priorities or things that need to be looked at on a statewide level or that you might want to help with. Next slide.
Okay, now we're going to talk about monitoring the disproportionate impact of discipline policies on our students. Next slide, please. And I don't know, some of you have been doing this for a long time. Sometimes you forget about ed code provisions that are good, and that has certainly happened to me on many occasions, and I kind of rediscovered Education Code Section 201, and it has wonderful language in it about the right to be free from discrimination, and this is part of it. I strongly recommend that you all go read this ed code provision to remind us that it exists. All pupils have the right to participate fully in the educational process, free from discrimination and harassment. And then California public schools have an affirmative obligation to combat racism, sexism, and other forms of bias, and a responsibility to provide equal educational opportunity. That language is in the ed code. So if we're talking about local control, then locally they're going to have to do this. So obviously if we're investigating as advocates the issue of discipline, and we find that discipline data shows that certain groups are being disproportionately suspended and expelled, that is certainly something that we can pursue, and we have good education code provisions that back our advocacy on this. Next. I'll talk a little more about data. One thing that I'm not necessarily addressing on the data issue I want to be sure and point out is special ed discipline data. And under IDAA, school districts in the state of California has to collect certain special ed school discipline. I'm not covering it here, but I can tell you, especially our special ed experts out there, I highly recommend that you go to their special ed website on CD to see what they're doing. They actually do have reports. I'm not as familiar with special ed as other people, and we're kind of looking into it because I'm unclear. It looks unclear to me whether or not the California Department of Education is doing it correctly. And if they're doing the sort of what the bare minimum required under federal law, we might want to, as advocates, ask them to do more. So, and again, if you want the link, it's hard to find sometimes. So if you can't find the link to these reports on special ed, just send me an email and I can send out the link. Anyway, getting back to my two main sources for discipline data is, again, DataQuest, which is found on the CDE website, and the Office for Civil Rights data collection. One of the materials we have for you on the LAC website is actually a memo that was drafted by a consultant for the California Endowment. And this is how to research California school suspension and expulsion data. She did a wonderful job. If you follow this memo, or for people who have never been on DataQuest or OCR, if you actually follow everything she says to do here, step by step, it'll teach you how to get the data on both OCR and DataQuest. If you've never been to DataQuest, you really do need to go there as an education advocate and see what's there. I always go there on any sort of issue that I'm involved in. I always go. The first thing I try to go is figure out what are the enrollment figures by race and ethnicity for a particular school district. I always go there first. It's really, really helpful on many, many issues. As I said before, currently DataQuest does not have disaggregated discipline data, but hopefully we'll have that soon. OCR's data is not disaggregated. It is disaggregated, but it doesn't provide the numbers by grounds, which is really important because we want to see how many African American kids, Latino kids are being suspended for willful defiance, that sort of thing. OCR has a lot more very interesting data. They have it actually subgrouped by LEP status. You can get at the site and the district level. They even have law enforcement referrals. So I do believe they also have special education data. So they have a wealth of information on the OCR website. I strongly recommend that you go there and just spend some time looking through and see what you can find. Let's see. And again, I also want to stress to you that you should, again, read Suspended Education in California. If we're talking about just general advocacy, I think this is a good time to try to do more formal advocacy in the area of disproportionate discipline. We could certainly use that sort of pressure in Sacramento, saying, you know, we're trying to reform school discipline issues through the legislative process, and we're getting some roadblocks. And, you know, now we have advocates out in the field, and they're beginning to file complaints because we just can't sit here anymore and let our kids be excluded. So if we had some more formalized complaints out in the community, that also would help us, and I believe, in Sacramento, and also kind of send a clear message to those school districts that are not taking this issue seriously. I know in the suspended education in California report, there's Table 2. It has the 10 California districts with the highest out-of-school suspension rates disaggregated by race and ethnicity, and they're there for the plucking. I mean, there's Manteca, Canachti, Visalia, Kern Union High School, Fairfield, Sassoon. Laura mentioned Vallejo apparently is already doing something. Jefferson Union High, Coalinga, Huron Joint Unified, Cochrane Joint Unified. Many of these school districts are in rural communities. They're ripe for investigation and hopefully more formalized advocacy. Also, in addition to the OCR data and data quest, we also have the school accountability report cards. Again, they only have suspension and expulsion rates for the past 3 years. But often, if you read the narrative sometimes in the SARCs, they give you some good information, especially with respect to how school districts refer kids to law enforcement. And the other thing I always do, I always comb a school district's website. And in this area, for instance, when I was looking at the data on Manteca and I found the high percentages of willful defiance for suspension, I also found that one high school district with the high rates of suspension and the highest enrollment data for African American students. I also found the data on OCR for that school district. I always try to figure out what is the makeup of the school board, and often I can kind of figure that out on their website to kind of get, does the school board adequately reflect the ethnic and racial makeup of the student population that they're there to serve. It kind of tells me some things in terms of who I'm dealing with. Next. And I know, if you try to get this information from school districts, sometimes it can be easy, sometimes it can be difficult. There is good information at 48916.1 saying what school discipline data school districts have to maintain, so we know that they have it. They also have to submit various information through CalPADS to the California Department of Education. Again, it'll be hopefully disaggregated soon. Some school districts, if you ask for the information, they already have it disaggregated, and they'll give it to you quite easily. Other school districts are going to want to charge, and I'm not going to mention the name of the district, $10,000 to produce it. I also think it would be a good tactic to maybe, if you have a friendly school board member, to have that school board member say, you know what, Superintendent, we're going to put this on the agenda for a school board meeting, and I want you to produce this data for us so we can have a public hearing on what the data is showing what the data is showing. We also have a sample Public Records Act request that we can send to you. We've actually gotten the expulsion and suspension notices sent out to all students that were redacted, and they can be very revealing, especially with respect to willful defiance, to see what exactly how this kid willfully defied. It can be very interesting. It's also my understanding that school districts are currently submitting their OCR data to the feds as we speak. A Public Records Act request requesting that data would be a very good thing to do. Next. Okay. I know there's some very experienced advocates on this call, on this webinar. We all have different ways of doing advocacy on school district issues. These are just some suggestions with respect to discipline. Again, all communities are different, so it kind of varies in terms of where you're doing your advocacy. In the past, if I had a group of parents, especially if they're limited English proficient or immigrant parents, I would often try to get them to have a meeting with the superintendent on whatever issue that I had going on in the district. It's a good way for the superintendent to get to know the parents, and it's a good way for the parents to get to know the superintendent. Also, as I mentioned, having a sympathetic school board put the issue of discriminatory discipline policies on the board's agenda and have a public hearing is also a good thing to do. I know that was done, I believe, by some CRLA advocates in the Oxnard area, and they actually got the district to actually develop a task force to look at problems of disproportionate discipline targeted at Latino communities in the district. With respect to formal complaints, I have not filed an Office for Civil Rights complaint for some time. I used to do it in the area of LEP rights. Certainly, the OCR has said that disproportionate discipline is a big issue for them right now. I have to believe that under this administration, things have gotten better, but I can't.
And Deborah, just really quickly on that, there actually have been 2 voluntary resolutions agreements in California, one in LA and one in Oakland. And again, we'll on fixedschooldiscipline.org pretty soon, those will be up, and you'll be able to actually access them. So you can see the one in Oakland in particular is quite detailed and really very strong. So,
Yeah.
and those are actually affirmative investigations that OCR took on. So there's not, and we have some samples too, if folks are interested, from folks around the state who are doing these in other places and have gotten some results from actually their, filing them. So if this is something that people are interested in,
Yeah.
give us
Actually, the resolution plan in LA actually came from an investigation on their LEP programs.
Right.
And
then the community, we gave them some additional information about what was happening with disproportionate discipline, and they got information from a variety of sources, and so they expanded it.
Yeah. I also am informed that they have been doing investigations in other states on disproportionate discipline, and that those decisions should be coming out shortly. So we'll see. Also, in the area of juvenile justice, they've actually done some really, really good investigations and done some really good analysis with respect to disproportionality in the area of juvenile justice, and they've kind of gone beyond what the law requires and really done some good stuff. So we'll hopefully they're going to be doing it. I haven't read some decisions on discipline yet, though. Now, next,
yeah, there's some good ones.
The Title V complaint process. I used to use it. Go back, please. I used to use the Title V complaint process all the time on LEP issues. At one time, I actually did a joint OCR and Title V complaint against a school district on LEP issues, and they did an excellent job. I have had, and this is my view, okay, I have had not much faith in the Title V process for a long time, simply because under the past administration, they just simply didn't like to monitor, nor did they like to tell school districts what to do. They rarely found noncompliance. I have stopped referring people in terms of Title V complaints. However, we have raised the issue with the department, and they are, because they're actually meeting with us now. This is a new administration. We haven't really gotten anywhere yet on it. However, if you're really having a school district that is really not responding to anything that you're trying to do, at least with the Title V complaint, you do have to file it with the district first, and they do have a time frame when they have to respond. So at least it may force them to at least start responding to the issue. All right, and then you can decide if you want to appeal your complaint if they deny it. And then, of course, this is seek legal assistance, but whether or not we want to look at litigation, that would be an entirely different webinar. So, but I think we need to start looking at that. Next, please. This is an important issue. Obviously, for you can't in the context of school discipline, notice to parents is very important. But an English-only notice to parents who are limited in their ability to speak English is totally meaningless. By failing to translate these notices to appropriate languages, and talk about discipline notices, school districts may be violating both state and federal law. And there are other laws that govern this. There's Title VI and the Government Code, but I'm going to focus on one education code provision. That's just a nice little education code provision that you can use that says when 15% or more of a student enrolled in a public school speak a single primary language other than English, all notices, reports, statements, and records sent to the parent of such students must be written in English and the primary language. And the way they calculate the 15% is by counting not just the kids who are limited English proficient or English learners, but they also count the kids who are SEP or formerly LEP. So basically those kids, all kids who come from a home where English is not the first language. So, and you can get the percentages for the school sites on DataQuest. You just go to under level, you press district. Under subject, you choose English learner under student demographics, and then you choose language group by school determined to meet 15% and above translation need. And then by way of example, I got the report for Fresno Unified, and some 90 out of the 110 sites in Fresno Unified met the 15% threshold.
And Deborah, just really quick before you go to the next slide, I just wanted to note actually David Usum, who's at Oakland, is on with us, and we want to just highlight, in fact, that the voluntary resolution agreement that they put in place, their board put in place, David and the superintendent, worked closely with the OCR to make that happen. And frankly, I do think it could be a model, and it will be up on Fixed School Discipline pretty soon, as well as more information about what Oakland's been doing with restorative justice and PBIS and SEL. They're putting in place a number of alternatives, and so just wanted to highlight that, just going back to the other piece that you talked about with OCR. So there are ways that districts themselves can affirmatively take the lead, again, taking affirmative steps to make these things happen.
Next, please. And again, you know, we have to keep on reminding ourselves that this is a civil rights issue, and we have to keep on reminding Sacramento that this is a civil rights issue. It's not a local control issue. Based on the OCR data and the willful defiance data, it's very clear we have a major civil rights, and I think, issue in our schools concerning disproportionate suspensions. And I was a little disappointed at the reaction from the OCR data. I didn't think we'd get this. I thought we would have a bigger response from Sacramento, but we didn't. But anyway, these students who in my view are being targeted for exclusion do end up in our juvenile justice system. I didn't used to like the whole pipeline to prison scenario. I thought it was too gimmicky. I'm totally convinced that it's true now. California's juvenile court school population is disproportionately youth of color, as Latino and African American youth comprise 80% of the juvenile court school enrollment. One study found that 80% of youth detained in our juvenile halls have been suspended at some point in school. 50% have been expelled prior to detention. Kids with one or more suspension are 5 times more likely to drop out of school. Anyway, so as an education advocate, I strongly urge you to give these issues your time. And if you're going to start looking at discipline issues, it would be great if you could also look at just other ways that our children are being excluded, whether they're being involuntarily placed into alternative schools, whether they're being involuntarily placed into alternative schools through the SAR process. There are many ways that these kids are essentially being excluded from schools. And with that, I refer to Laura.
Next slide. Last slide, I say.
Yep.
So this last slide is just another pitch. We really want to increase the number of people that are engaged around this issue. We want all of you involved. We'd like for you to tell more people. We'd like for you to forward this PowerPoint. We'd like for you to take the fact sheets and bring them out into your community. We want you to get involved because we really are trying to create a movement here around the state, get as many folks engaged in this issue as possible. A tool that is very easy for you to go to, fixschooldiscipline.org. It's up now. You can go right to the site. It has many, many tools on this issue. It has fact sheets with harms, all the harms that we're talking about, all the data. It has pretty much most of the articles that have been written in the last year and a half about school discipline all around the state and nationally. It's going to have very, very soon, at the end of this month, we will have 2 toolkits for you. One is going to be actually directed towards schools and school districts and school leaders, and one is for community. And the purpose of these toolkits is really to give step-by-step help and advice and instructions on how you can actually get alternatives in place as school-wide and district-wide solutions in the communities you're working with. Because what we see, again, when these alternatives take the place of our traditional punitive discipline regime, we see great changes. We not only see that our suspensions can reduce up to 60, 80% in some places. We have one school that's highlighted in the toolkit that went to 1 suspension a year from over 600, I believe. We not only see that, but what we see is that the academic performance index rates go up. So every child in the school is benefiting. We see the attendance go up. So it really is a win-win, and I'm not just saying this lightly. I know that's an overused term, but it really is for everyone. You get better school climate. You actually get teachers are happier. They feel more like the school has greater structure. The students are happier. There's more parent engagement. So it's not a joke. If we do this, this is really the fundamental, I say structural fundamental changes that need to happen in our schools in order to really transform and get our children to where we want them to be. So really encourage you to go to fixschooldiscipline.org and get involved because this is also a place where if you just sign up on our website, then you'll also get alerts about what's happening on the state level with policy, with research, things and other tools that you can use throughout the year, and you'll be connected with a network of folks. We're also going to have some more webinars throughout the year about how you can actually get these things in place. We will be hopefully having people from various school districts also participate in some of these webinars to tell their stories about how they're putting things in place. We'll have community leaders who have helped push to get resolutions. Maybe some of you will do that, so you'll tell us about it, and we'll try to get you to tell your story as well. So please go to fixschooldiscipline.org and join us. Join us in this and learn more and get engaged. And we're going to turn it over now for the last 15 minutes for anyone that has questions. I know some of you have already done,
we have a lot of
some
questions.
of them online.
I would
Okay.
just add,
Some of
Deborah,
them
that
we answered during the process, but I'm not certain.
I'm sorry. One more thing. For those of you who are with IOLTA programs, or if you're not part of the education task force and you'd like to be part of it, just send me an email. I'll get you on the task force and the listserv. Oftentimes we talk about discipline. There's also a School to Nowhere task force for IOLTA programs where we specifically talk about issues of exclusion. So I know some of you have really kind of specific, you want to talk about a case or you want to do a formal complaint of some kind, we do have that sort of availability to talk specifically about the cases that you're dealing with. So just send me an email, I'll get you on them.
Okay. So the first question that we have is, do districts need to distribute the new rules and policies in January because these go into effect in January, or can they distribute August and September when the 2013-14 year starts?
So my answer to that question is January 1 is the effective date of the legislation, so everybody has to follow the law as of January 1. Now the question is, obviously, there's going to be some time, it can take some time to change policy, right? So the important thing is that the law must be followed as of January 1, but in order to sometimes get the procedures in place on the variety of these things, it may take a little bit longer for that to happen.
The other thing to keep in mind, and I don't know if you guys have ever, if those of you have gone to look at school districts' discipline policies, they often get their policies from the California School Boards Association, because CSB has their sort of model discipline policies. In fact, I think someone just sent me the most recent ones. I have to assume that CSB is going to be sending out some new ones shortly based on these new laws, or maybe Laura can talk to them about that. But
yeah, we're hoping that so what's wonderful, I think, is that because we're actually dialoguing with the School Boards Association and AXA and stuff, but we're really encouraged, which is great, is that we're going to try to hopefully work with them together on some of that.
Yeah. The other thing is oftentimes school districts don't change their policies. So our kind of message to you is this is an opportunity as advocates to go to them and say, you know what, we have some new laws here. You're going to need to change your policies. Here are the issues. We want you to start that process sooner than later.
Okay. So the next question that we have is, how quickly can we reasonably expect LEAs will update their policies to reflect these new laws?
And again, I think the same answer we sort of gave, which is really it's going to depend on some local advocacy, and it will depend on the district. Some districts are going to do it quickly. I really have gotten a few emails already from people who are saying we're already starting the process. So I think it's going to be a site-by-site thing.
But again, I want to stress everybody, it's kind of an opportunity to go into look at the issue in general, not just about new policies, which they should have, but also other means of correction. Oftentimes districts don't have any policies on other means of correction, or they just regurgitate whatever the ed code says. It's for them to really examine what they're actually doing with respect to this and to start looking at the data.
So really, we'd love for every single one of you, when you get off this call today, for you to start setting up those meetings in your communities.
Okay. So the next question that I have is,
Actually, Patrick, can I stop you for a second? I just want to go back to Carrie's first question. In terms of the data and whether or not it includes, I think she said suspended expulsions. Let me see. I'm almost certain that the data I gave you is just really just real suspensions and expulsions. I'm not sure what they're going to be collecting next. I'll have to look at CalPads. It's pretty complicated, but I'll try to find that out hopefully on Monday.
Yeah, I'm pretty certain that it's just the expulsions, the final expulsions, because we had to look at this pretty closely.
Okay.
Sorry, Patrick.
No, it's really fine. So the next question is, if the state is ultimately responsible for ensuring equal opportunity, is one possible method of accountability when these laws are not followed and they involve school districts aren't cooperating to file suit against the state for failing to ensure equal opportunity?
Well, I guess so. I would probably at this point kind of deal with the local school district, having litigated several cases concerning the monitoring obligation of the state of California and not been very successful at it. I would not necessarily go that route.
So I think what Deborah, I think the answer I would give is a little different than Deborah's. I think it's going to depend on the facts that we have and what's going on, and there are obviously different mechanisms. So I think, as Deborah, you said another time, this could be a different call. But I think it really is pretty fact-based, and also there may be other methods. When we've, for example, filed a writ and the writ is against both the state entity and the local entity, or it's a narrow suit against both. I mean, it's going to really depend on what the facts are and what's happening, because some of the laws we're talking about are laws that may have to be enforced via writ, and other ones would be ones that would be enforced, obviously, could be enforced in state court and even possibly in federal court, depending on the violations.
Okay, so we have a couple of really long questions and statements. I'm not sure if you both want to look at those before answering them. But in the meantime, there is one question. Has there been any discussion on expulsion from preschools?
Yeah. Hi, Helen. Yeah, there has been some discussion, but I have to be honest that the folks that have been engaging around this statewide that I've been talking to, we've only really most recently begun that discussion, and I would love to get some input from anyone about thoughts about this. Obviously the preschool context is a little bit different in terms of the codes that apply and sort of the regime, because preschool is not a fundamental right. And so I think it's a really interesting question. I just saw two pretty shocking studies about the expulsions and obviously the impact of them. So would really love any thoughts that people have about what we might do about that, and whether it's policy or programmatic, because it obviously does have long-term impacts.
The next question is, would people be able to submit questions to the I Need Help program in Spanish? Would they get answers in Spanish? And would it be better for someone to get an advocate to submit issues in English?
Oh, that's a wonderful question. So we should have the Fixed School Discipline website. If you go to it now, you should be able to actually, there's a link on it, I don't remember where it is, goes to a Spanish website. So everything on Fixed School Discipline is translated into Spanish, and the toolkits will be as well. There may be a little bit of a delay, but yes, there's the Spanish and English versions, and the I Need Help will be in Spanish too. The question will really be, if you submit it in Spanish, it just may take a teeny bit longer to get back, because the staff person who's going to be doing it does not speak Spanish at the time, who will be taking the first round of things. But yes, we should be able to provide some assistance in Spanish, and it just may take a little bit longer than we would like at this point in terms of getting back to you right away. And then there was one other question, Patrick, that I saw that was up above that is, I think, believes from Timothy McKinley.
Yes, I was actually, if you wanted to paraphrase it, or at least that's fine, since you were looking at the questions too.
It's a really important question. Timothy, who has been working in Kern, is saying that the high school district now is moving to a heavy reliance on involuntary transfers to continuation schools, and so circumventing the expulsion process, basically. And that it seems that they may also be restating the expulsion rates by redefining a number of the expulsions as involuntary transfers. And so there are a couple things. So the first issue, obviously, is if there, the Education Code has a number of protections around continuation schools in terms of when you can actually send a child to continuation school and their rights regarding that, and there are hearing procedures for young people who are being transferred involuntarily to a continuation school. I would imagine that at some point in time, if they're trying to do that, that the continuation schools are not going to be able to hold the capacity, and so there'll be other educational violations. It would be interesting to try to do a PRA request to figure out how many and what's happening, and whether, in fact, the reasons for which children are being transferred to the continuation schools fit in with what's allowed under the law, and also to proceed and use the, which Timothy, I imagine you're probably already doing, using the more limited protections for those young people, and actually going through the process of the due process protections that are provided for continuation school transfers. And potentially, if they are not being followed, I would think that, and ultimately, if you can show it, that a writ proceeding might work to deal with that. The second piece, the second question about expulsions that are being redefined as involuntary transfers. We had a case that was very similar to this, where it really truly was an expulsion, but they didn't give any of the expulsion due process procedural protections, and instead involuntarily transferred. And we were able to successfully argue that that was a violation of the student's due process rights. So I think it would be a very would be very fact-specific, but finding a few good cases to look at this if really what is happening is that the child is not getting back in school, is actually not getting into a school. I think also important is this is an area in terms of involuntary transfers where there has to be protections. And in Philadelphia, I believe there was actually a very good case that was brought around this practice because they were able to show it's systemic and that the transfers themselves, it was a transfer to nowhere, meaning that when a child was being transferred, they didn't actually have another school to go to. They were out of school for multiple days. Parents couldn't get there because there was a lack of transportation. So it really actually was an expulsion, in fact. And the number of days, obviously, that the child was out of school increased their requirement to actually get more due process. So I think, again, it would be fact specific. In terms of amending the student's records to delete the expulsion, so if they've actually said it's an expulsion recommendation or they've, in fact, somehow put that in the child's record, but in fact they're involuntarily transferring them instead, there is Education Code provision 49070, and that is a rescission record removal provision that I think is a very good provision to use when you think that a child's records have incorrect or information that is not actually true, and you can use that to remove that. Obviously making a request for all the records, looking at what the records are, and then going forward with requesting the removal or rescission of things that are incorrect. I hope that answers or gives some thoughts. I don't know if Deborah has others.
Nope. Involuntary transfer is not just a continuation school, high schools, but to other alternative schools is a major issue. And also, we've heard stipulated expulsions. That's a major issue out there. And actually I've heard in one county where this is actually a school district attorney was telling me that there are very little appeals to the County Board of Ed anymore because most of the expulsions are being stipulated to.
I want to just add also that Ann Zachary, also I was assuming in my mind that the young people that Timothy's been talking about are students not in special education, but she's absolutely right that also, of course, the rights of special education students include filing for due process, depending on what's happening, expedited due process, and also invoking their right to stay put. So thanks, Ann, for bringing that up. Are there any other questions?
It doesn't look like it right now. So we have about 4 minutes left, so we can, one just came in. So the question is, since the continuation schools provide less credits per semester, students are sometimes not eligible to return to the district after an involuntary transfer. They are essentially permanently removed from the district. Do you have any thoughts on that?
That's interesting, Phyllis. I've never read. I need to look back. I don't want to talk off the top of my head because I don't have the continuation school statute in front of me.
I thought there was a specific provision about when you have to return after.
Yeah. Again, I don't want to. What I would love to do is take a look at that. Pull that section out, and if you wanted to email me separately, I can sort of walk through with you. But my recollection, very vaguely, and again, I should probably just not say anything because I can't remember exactly. But I don't think that there's procedures where they have to actually have some sort of hearing and they have some rights to return. So I think that should not be happening. And so if that is happening, that's really problematic because that's something that really pretty much undermines all the other protections in the statute. The continuation school is not supposed to be the permanent placement for the child, right? So I would, if that's something that is actually you're seeing in your community on a wide scale, or you have a number of cases about it, I think both Deborah and I would really love to talk with you more about that because we'd want to look and see if there's something in the law that's making that happen. There's some sort of exception that people are relying on that we're not, thinking about, or if this really is just a, straight violation, something that should be addressed because that shouldn't be happening. Oh, right. We don't have our email addresses on this website. This is a webinar. Very, very good point. So my email is, and what we'll do is, I think, Patrick, can we send out, when we send out the fact sheets, can we also send out our emails to everybody? Will it get to everybody on the list?
Yes, actually. If you want to send me those fact sheets, maybe today, I will be able to get those out as along with the MCLE, hopefully in a couple of hours or so, and I can put your email addresses down there as well.
Great. And mine is lfaer@publiccounsel.org. So if you wanted to write it down now, but we'll send it out by email later on.
So there's one question that came in. How about after-school elementary programs with some sorry, I can't.
Maybe that's nexus with the public school? I'm not certain what the question, is it a
Yes.
question of children being, I'm not certain I understand the question, but is the question, are there any rights that children have to due process if they're being removed from an after-school program with some nexus with the public school? Is that the question? Kirk? Maybe he can.
I don't understand the question.
Hoping he's going to type something else to us.
And if not, of course, you can always feel free to email the presenters afterward.
There, our good friend David Sapp. Thank you for looking up the code section. I knew you were out there in the world. 484-3.2, the involuntary transfer to the continuation school. And yes, as we vaguely remembered, all of us, it should not be extending past the end of the next semester. The other person who had the question, again, Phyllis, if you wanted to chat with us, please email us so we can talk with you and understand a little bit more about how this is happening or how you're seeing it.
But you know what? I mean, it's not just continuation high schools. Too many kids are being involuntary transferred to these other alternative schools. And I've noticed that, at least in the SARB referrals, they get referred for being truant, and then they get into, say, a county community school or community day school, and that particular school tacks on additional criteria that they have to follow in order to eventually transfer out. For instance, they have to maintain a 3.0 GPA. They've never had a 3.0 GPA in their entire life. But so we definitely have to start looking at continuation. I mean, at alternative schools in general. The continuation high school statutes are at least somewhat good, but the other statutes are just horrible. Just horrible.
So it's, again, the question is, the final question, and then I think we should let everybody go because you've been with us for an hour and a half, is 48432, Ed Code section 48432.5 is the continuation school section that really does lay out those protections and sort of the process that has to go through and when you can and cannot actually transfer to a child to a continuation school. All right, I think we're good, Patrick?
I think we're all good for right now since it is 3:30. So I'm going to wrap up this webinar. Again, thank you all for joining us for today's webinar, and thank you so much, Deborah and Laura, for sharing this presentation with us today. If you have any questions regarding LAC trainings, please email me at pfodel@laconline.org or by phone at 415-834-0100 extension 312. I will send MCLE materials after reviewing participant and in-session times. Please note that you may not receive your MCLE certificate for a few days. The Legal Aid Association of California is a membership organization for IOLTA-funded nonprofits. Our job is to advocate on behalf of California's legal services community. We have in-person meetings throughout the year in California from San Diego to Sacramento, and we would love to see you in person. LAC has several upcoming webinars, and we'll have many more in 2013. If you're interested, please go to laconline.org/coming up for a complete listing of scheduled webinars. If you have any questions, please email me at pfodel@laconline.org. We hope you'll be able to join us. Thank you all again, and have a great afternoon.